what happens when the person or persons nominated in your estate planning documents, let's say in your will, your power of attorney, your trust, what happens when one or more people die before you or even at the same time with you? So let's talk about it. A power of attorney is a document that says when I become incapacitated, if I become incapacitated, unable to take care of my affairs, I appoint this person as my power of attorney. So if that person dies before you, or maybe if they become incapacitated, or maybe they're not interested or willing to serve as your power of attorney, then what? Then most power of attorneys, and I hope yours, if you have one, it does, have an alternate designation. That says, let's say, if I become incapacitated, I appoint my spouse as my power of attorney. If my spouse predeceases, is unwilling to serve, unable to serve, then I appoint my son, or then I appoint my mom, or my daughter, or my friend, and so on. So if the first person dies or is unable to serve, then it goes down to the second one. What happens if the second one dies as well, or may not be interested in serving? Then you have no power of attorney, which can be pretty serious, because if you don't have a power of attorney and you become unable to make decisions, a guardianship proceeding will have to be filed, meaning that someone will have to go in front of a judge and say, hey judge, they're incapacitated, allow us to make decisions for them, because the two power of attorneys, the two people they nominated in the document, are either deceased or unwilling or unable to serve. The same thing with the will. The will, you usually have, when I die, I appoint my spouse, my son, my friend, my cousin as my personal representative. If they're unable to serve, then I appoint someone else. With the will, if you don't have a personal representative willing to serve, or if they predeceased, it's not a big deal, because a will usually will have to be probated anyway, and then the court will just appoint someone else. The power of attorney is a bigger deal. So if the people you have in the document tell you that they're not willing to serve, or maybe something happens to them, you may want to update that power of attorney. Let's talk about a trust. The same thing with trustees. I appoint so-and-so, my spouse, my kids, my friend, my cousin, as my trustee, as my successor trustee. Again, if you become unable to manage your affairs or when you die. Usually a trust, a comprehensive trust would say, if the first person cannot do it, then I appoint another one. Then if the second person cannot do it, or if they predeceased, I appoint a third one. Or sometimes people designate a panel of people. Let's say my 3 kids will get together and appoint someone, and so on. So there are ways. Make sure your documents include these alternate options, so you don't have to automatically renew the documents if something happens, at least to the first person. Thank you for watching. I hope you found this video helpful. Be sure to subscribe to our YouTube channel, like us on Facebook so you get notifications when new videos are posted. If you have ideas for new topics, please email them to me. I would love to hear from you and create videos that can help you and other people in your situation. Visit our website, maybe join us in our in-person educational events at the Well here in Norman. Have a great day.